published a little while ago, arising from a project exploring the impact of gene patents on genetic testing. Now, although there have been developments in the law relating to gene patents in the past few years, with the myriad cases in the US and Australia, and increasingly a number of cases around diagnostic testing, controversies still persist about the potential for patents in the field of genetics to affect access to diagnostic testing. And that is the focus of this talk. So first, as background, it's important to note that there are numerous patents on human genes. And whilst there's some divergence in opinion as to how much of a problem these are, there are at least two different types that are problematic for genetic testing. The first, and perhaps the most controversial in terms of the popular literature, is product claims to isolated genetic sequences. And this was very much the focus of the US case in the Supreme Court around myriad genetics. Secondly, there are also concerns about method claims, so methods of diagnosing genetic diseases. And these are, it seems, in some ways more problematic and more likely to block the use of or the genetic testing in clinical use. Second area of background is in relation to genetic testing. And genetic testing is still the main clinical application of genetics research and the main output at the moment of the Human Genome Project. Clinically, genetic testing can be for rare diseases such as cystic fibrosis or Huntington's disease, and it's increasingly used to target clinical treatment. So, for example, pharmacogenetic testing can be helpful to determine appropriate drug dosage regimes and also to avoid serious adverse effects of drugs in people with particular susceptibilities as diagnosed through genetic testing. In the UK, genetic testing is almost exclusively conducted by the NHS for clinical purposes, and much of it is still in the form of some homebrew testing. So this is not the sort of commercially developed kit test, but a sort of test that is made from first principles by a laboratory from looking at openly accessible genetic information databases and academic publications. As we move away from these types of tests into more sophisticated whole genome sequencing and those sorts of things, the law moves on somewhat. But the focus of my talk today is this sort of homebrew genetic testing that is conducted in labs. And what is fairly clear is that genetic testing, as conducted by public sector laboratories, the NHS and other public sector laboratories in Europe, falls within the scope of at least some gene patents. And there's a particularly influential publication by Van Overwaal and her colleagues doing an analysis of gene patent claims. And it's clear that genetic testing does fall within the scope of those patents. And whilst it's possible to invent around some of those patent claims, it isn't possible to invent around all of those claims. Now, what is the problem? Well, there are two problems, I suggest, that we need to be concerned about. And the first of these is what I term access to medicine type concerns. These are the sorts of issues that are fairly well recognized in relation to the problems of patents for medicine. Firstly, there are concerns about the increasing cost of genetic, that patents result in for genetic testing. These concerns arise from patent thickets, where there are lots of overlapping patents, which is necessary to license or otherwise overcome or invent around in order to conduct a particular genetic test. The concern of the possibility that these multiple patents, once licensed, result in multiple royalties, which can make the test excessively expensive. But also the concern of the transaction costs in mapping the patent landscape, identifying the relevant patents, either inventing around or licensing those patents. All of these increase the costs of carrying out those tests. And these transaction costs are particularly burdensome in the public sector, where there is much less awareness of how to address these issues. Importantly as well, there are concerns about the monopoly nature of patenting causing problems where there are no alternative providers for second opinion testing or validation testing. This was something that was raised in relation to the myriad gene patent situation, where those who were given particular results, certainly in relation to variants of unknown significance, were not able to access alternative providers and weren't able to get a second opinion on whether or not that variant of unknown significance was likely to be benign or pathogenic in a particular case. There are also concerns in relation to this of the likelihood that patents can result in the concentration of expertise in a single provider. And here we see a link between the situation where you have a patent which allows you to then build up your database of information and develop a great body of trade secrets, which allow you to then increase your monopoly once the patent has expired. So this link between patents and trade secrets was particularly concerning. Again, we see this in relation to the Myriad case, but concerns relate to the operation of patents in genetic diagnostics generally. So these are the concerns that are particularly relevant for access to medicine. But what we see when we look at the actual evidence of these problems in practice is somewhat different. And the empirical evidence across Europe from when these problems were first being discussed and researched, and indeed continuing since then, suggests that gene patents are not actually causing these appreciable access problems in practice. And what we see from a number of studies, one of which I conducted and which was published in 2011, was that gene patents were largely ignored in the public sector for various reasons. And these other studies have found similar things. Study by Hopkins and colleagues published in Nature in 2009. And more recently, John Liddicoat, Kathy Liddell and colleagues have found similar things across Europe, although they do highlight that there is perhaps a growing evidence of problems in relation to some of the newer technologies particularly. So what is the problem with this? And there are a few different positions we can see in relation to whether or not this lack of engagement with patent law is problematic. So if you come at this from a public interest, public sector approach, public access to medicine approach, it's possible to see this as entirely unproblematic. The concern, if your concern is primarily whether or not a patient can access medicine, a situation where that patient is accessing the necessary medical treatment without any blocks can be seen as unproblematic. At the same time, if you come at this from maybe a law and economics approach, you can also see this as unproblematic. You can argue that the whole purpose of the patent system is that rights holders are able to choose to access their rights, that they can engage in a process of rational forbearance if they choose, and should they choose to do so, if there is non-compliance, as I've termed it, then this is unproblematic. It is simply the patent system operating as it should. My position is somewhere in the middle. I argue that because these rights exist, they can, in fact, be exercised, and that the current system is only in equilibrium because of a number of factors. But if any one of these factors changes, for example, there could be an increase in enforcement, then the whole system can change because it depends on all of these factors in balance, and that the NHS suddenly becoming risk averse and stopping genetic testing could be very problematic in terms of patient access. And we should not therefore rely on this system of equilibrium that is built on a system of non-compliance, if you like. So as a result, I argue that these two problems, the theoretical, if you like, access to medicine problem and the law and practice problem of non-compliance, can be addressed by a single solution, which is an exception to infringement for genetic testing. And what I argue is that we should insert this exception under section 60 subsection 5 of the UK Patents Act. and add in a subsection where an act which, apart from this subsection, would constitute an infringement of a patent for an invention shall not do so if it consists of the examination of the genetic sequence of an individual in accordance with a request for testing by a registered medical practitioner. And this text mirrors the extemporaneous medicaments exception, which you can see on the slide. And here, I would argue that genetic testing in terms of a home brewed test is very similar in terms of subject matter to a pharmacist who prepares a medicine extemporaneously in a pharmacy without infringing a patent. So a pharmacist who makes up an ointment, for example, will not be held to have infringed a patent, even if a patent exists for what they've done. And this is a relatively rarely used exception at present because virtually all medicines are bought from a pharmaceutical company that makes them in a factory. So what you can see is that there is a parallel here. If there is a diagnostic test that is a kit test, or it is part of a bigger system, if you like, that is not the sort of homebrew testing I've been talking about, then that would not fall within the terms of the exception. But the sort of homebrew test, which is very similar to an extemporaneous medicament preparation, would fall within this. And I would argue that there's a similar rationale for both exceptions. So this is on the basis of public health and a desire that patent law not inhibit the actions of medical practitioners or allied health professionals. And we see a history of this in terms of the development of the law in this field. So why is this exception beneficial, or how would it solve these problems? Well, if we look first at the access to medicine issue, I argue that this exception allows, particularly the public sector, but laboratories, to conduct necessary diagnostic testing in that homebrew form. And it means, importantly, that the diagnostic monopoly will be avoided. So the genetics community, as I've said, have often argued that these monopolies in testing are very detrimental, and that there's a need for the diversity of experience in testing and for multiple labs to have that ability to perform tests. And this exception will permit that in law. Importantly as well, it will enhance the congruence between law and practice. So this exception maps onto current behaviour, particularly in the UK, but also across Europe. So it will legitimise the behaviour that is currently continuing and ultimately is resulting in patient access. Of course, there are other ways that law and practice could become more congruent. An education program might be able to change behaviour to encourage licensing. Although I would argue that there has been education, certainly a number of these sorts of education programs have been put in place over the years with relatively little impact on behaviour. And it will be very difficult to change behaviour, particularly where the individuals concerned are motivated by a strong moral commitment to providing medicine to their patients, unless there is some imperative or incentive to change that behaviour. Another way that congruence between law and practice could come into play is through increased enforcement action, but this is likely to reduce patient access. And similarly, if there was increased licensing, it's possible that could improve compliance, but the increased costs involved in licensing are likely to reduce patient access. Similarly, compulsory licensing is unlikely to be legally very helpful in the case of genetic diagnostics. It's simply not feasible under the TRIPS conditions in this case. It's also, I think, worthwhile to note that if we see a move more towards congruence between law and practice, what we see that in relation to non-invasive prenatal testing, and the empirical work I've done in relation to that type of testing has been that there has been much more concern about the enforcement behaviour of patent holders and much less willingness to engage in testing where there is known to be an aggressive patent holder. And what this has resulted in is decreased access of the public to that testing. So compliance without appropriate attention to access to medicine will decrease that access. And it's important to consider both if our concern is about ensuring access to patient testing. So just to conclude, I want to argue about or discuss why I think it's important to aim for compliance in this case. And many argue, as I've said earlier, that the patent system is designed so that private actors choose how to behave. And accordingly, if there is lack of compliance with law, it is either temporary or it's a rational response to market conditions, and that the market should be left to resolve the issue. And whilst I have some sympathy with this approach, I argue that it's an excessively market-focused approach, and it fails where there is a strong public interest in access to technology. And when we are thinking about questions of access to genetic testing, then there is such a strong public interest. And it's important in such cases that this equilibrium of access that exists because of this culture of non-compliance, that shouldn't be disturbed. And accordingly, I would say there is a strong argument that the law should step in to protect the public interest in access to medicine, and that the limited and focused exception I've set out in this discussion would be an appropriate way of doing so.